Good morning and a warm welcome to KBC News Check on this 6th day of July 2022. I'm hoping that you're having a fruitful day. It's time to check on what is currently happening or what is hitting the headlines in the country. Of course, matters politics take precedent, looking at the campaign trails that are currently underway. All the four presidential candidates are bait at this moment are currently drumming up their political drums and traversing all the parts of the country, from the north to the south, from the east to the west, selling their agenda. All the manifestos have already been launched by all the four presidential candidates. Good morning, my name is Njue, and for this first hour we are going to look at the state of politics. Mostly we're going to look at the election preparedness. Why? Yesterday the High Court pronounced itself on a certain judgment. Justice Anthony Mrima did declare some of the requirements by presidential candidates, and in particular talking about the photocopy of identity cards, of which all the presidential candidates were required to avail to the IEBC so as to be cleared. He declared that as unconstitutional, basing it on the Data Protection Act, of which he talked about. IEBC do not have a clear plan on how they are going to protect data that they get from this photocopied ID for the candidates. That's just from one of the issues. And remember, it's only 33 days to the general polls. Printing has already started in Athens, Greece. So what does this mean? On our sign language interpretation, we have my colleague Byron Abuli. Of course, you can be part of this conversation through all our social media platform. We are live. Now, straight to our conversation, and joining me on set are two gentlemen, and they happen to be advocates of the High Court. They did follow on that judgment, and what can we get from that? And how does it change the political game plan of the country? And especially, we have less than 35 days to the general polls. Good morning. On my immediate left, Wambui Shadrak, Council.
Yes.
Thank you so much for making time.
Asante sana Ben. It's always a pleasure to be here. Good morning to our viewers.
As it is always ours.
Thank you.
And we have also Gibson Gisore, who is also an advocate of the High Court. Gentlemen,
yes.
Were you surprised with Justice Anthony Mrima's judgment yesterday? He is known for having quite some heavy or weighty judgments, and we are 33 days to the general poll, and he says that his judgment could render the four candidates, we could have more candidates than the four that you already know. He did talk about that the IBC do not have a clear plan on how they would protect that, and he said that is unconstitutional, which could be interpreted into so many ways. But you are the advocate of the High Court. Kindly, what does Justice Anthony Mrima, in a nutshell and in very simple English, what does that mean?
Well, I mean, Justice Anthony Mrima, my lord, is increasingly becoming the lion of the Constitution, a phrase that was used previously to refer to Justice John Mativo while he was at the Constitutional Division in Nairobi. But since he departed to Mombasa, I think the person who has occupied that space quite well is Justice Anthony Mrima. And the decision in question, which has in essence declared some provisions, some rules in the election regulations of the year 2012 as unconstitutional, of course is expected in perhaps the ordinary sense of the word to have some consequences, perhaps in what the IBC has done and perhaps even moving forward, just to be specific. So number one, well, the court just did its duty, really. The court's duty, while exercising its mandate under Article 165, is to just, look at provisions of the law and regulations and place them side by side with the Constitution and decide whether they pass the muster of the Constitution. So from the court's considered judgment and view is that those rules, in the manner they have been framed, they are actually discriminatory. they give other candidates who are in political parties, the outfit of a political party, they give them an unfair advantage as opposed to people who are running as independent candidates. So what the law expects, and this is what the court was saying, is that number one, even while we must look at the Data Protection Act, there is a constitutional threshold of fairness. And you must not discriminate against candidates in an election. So that is the heart of the judgment of the court, or rather the reasoning of the court that led it to deciding in the manner in which it decided. But now if you are to give a fair view of the effect,
yes,
will the decision of my Lord Justice Anthony Mrima have a retrospective effect, or will we be having a proactive effect, so that will the effect be in the future, so that we should be considering the elections of the year 2026 and 2027, or will it have now an effect on this election? And I know that is the elephant in the room. This is probably what has caused a lot of discomfort, and perhaps this is where your question is actually premised on. Now, to respond to that question quite comprehensively, the Supreme Court has dealt with this question previously, and so fairly speaking, it is not a lion or the elephant in the room, because if you consider in the past where Mary Wambui was running for the seat in this is Nyeri County. Yes. She sought to be the member of National Assembly representing Nyeri. And also the case, I'm going to compare with the case of Hassan Ali Joho. You remember Shabal had challenged the election of Joho. And there was a challenge on the constitutionality of Section 76(1)(a) of the Elections Act. Remember, the Elections Act then provided that you are supposed to file your election petition within 30 days. While the law, the Constitution under Article 87 provides that you're supposed to challenge the elections. After the declaration, you're supposed to file the election petition within 28 days. So there was a point of departure between the Elections Act requiring 30 days of filing the election petition and the Constitution requiring that you file your petition within 28 days. So the court, in Mary Wambui's decision, which went all the way to the Supreme Court, and the Supreme Court decided on the issue, declared, of course, affirmed the High Court's decision, declaring Section 76 as unconstitutional, because the measure of the constitutionality is on the Constitution. Yes. The Constitution under Article 2 says it is the supreme law. Yes. So all other laws are subordinate, they bow to the Constitution. Yeah. So the Supreme Court decided in this case that this law was unconstitutional from the point of its enactment. And in essence, what it said is that it gave a retrospective implementation of the declaration of the law. So that even while you are doing that act, knowing very well that it was legal, the Constitution is saying this is an illegal position. So the act was a nullity from the word go. And that is what the citizens should understand from at least the Mary Wambui's decision. But when you turn to the Joho's decision, because these two decisions are going to play out, and depending on how the IBC will choose to look at it, and the likes of Dr. Ekuro Kot and Kigame and the rest who challenged. So when you turn to the Joho's decision, the court is saying, even while we acknowledge our reasoning in the Mary Wambui's decision, where the unconstitutionality goes to the point of enactment of the law, retrospective application. The court considered the jurisprudence or the reasoning of courts and the law in South Africa. So that in South Africa, even while the court has the power to declare a section as unconstitutional, the court has to decide on a case-by-case basis as to the extent of the retrospective application of that declaration. So that, of course, looking at the elections right now, the person applying for the declaration of this section as unconstitutional or regulation as unconstitutional must also move the court to direct or make directions as to the level of how backward this declaration will apply. And
I believe that is what all Kenyans are looking at.
Yes,
because what we've had is that the ballot papers have already started to be printed. Okay, we do not know the finer details on which ballot papers they've already started printing. And what is the ripple effect that we expect from this judgment? Of course, we do expect that somebody will move to court, or IBC could move to court to challenge that at the Court of Appeal.
They've already moved.
They have already moved?
Yes.
All right. Now we expect the Court of Appeal to pronounce itself on the matter. And there's also another window, the apex court, that is the Supreme Court. So what should Kenyans expect?
Now, what the Kenyans should expect is, number one, if you look at the prayers that were sought by the petitioners before Justice Anthony Mrima, they did not seek for an order of mandamus. They only sought for, you know, their judicial review orders. I need to digest it for the purpose of, you know, our viewers understanding what we are discussing.
Beginning with the mandamus, yeah?
Yes. So their judicial review reliefs, there are prayers that you go to court and ask for. And one of these traditional prayers was to, you ask the court to cancel what was required of you. So that the court has said through an order called certiorari, it has quashed that requirement because it has quashed those provisions of the law. Now, over and above that, the people who are going to court ought to have prayed. You know, you are given what you pray for. So that they ought to have prayed that now, following the declaration, as a consequence of this declaration, the court ought to have been persuaded now to give an order compelling the IBC to consider their documents. But now that was not sought. So to that extent, I feel, as a practitioner of law, that to that extent, then they will need probably to approach the court again with an application.
We are talking about the High Court now.
Yes, the High Court. But you see, the IBC can as well say, well, even with this decision, and perhaps going by the determination that was had by the Supreme Court in the Joho's case, the court ought to have directed on the extent to which this retrospective application will have been. And to the extent that it was not sought by the petitioners, then the IBC will be home and dry and say, you know, we will apply it moving forward. Yes. So it depends largely with the application of the jurisprudence that is flowing from the Supreme Court. So it is not really an open and shut question as to whether we are going to reopen the process or not. Remember, the discretion, Joho's case returns the discretion of the court. You have seen in the previous past where Justice Anthony Mrima, my lord, has said that, you see, even with the transfer of the functions of the Kenya Meat Commission to the Kenya Defence Forces, the court declares that as unconstitutional, but says, I'm giving you a reprieve. You have until 6 months to implement that decision I have made. You have seen, even in other cases, where my lord Justice Anthony Mrima has said that the CAS, that position in itself is unconstitutional. But it has, but it has given the president a reprieve of 12 months. So you have 12 months to implement that decision. So what does that mean? It means that the court has discretion to direct us on you know, the timelines of application. And this declaration, the declaration of Justice Anthony Mrima that was made yesterday, does not set those timelines, which gives the IBC, in my view, an opportunity of saying, well, moving forward, we will look at it.
Okay. We are only 33, Gibson, we are only 33 days to the general poll. And I'm quite sure this pronouncement opens up everything, even can of worms, because the other candidates who are disqualified could argue, or could apply, as Wakili has said here, could also apply and say, now we need to be at the ballot. And the timelines, the papers have already started to be printed in Athens, Greece.
Yes, that is a very big problem as it stands, but as Shadrak, Wakili here, a very good friend of mine, has just elaborated, there is that particular issue that we have to deal with. You know, you realize you are actually not supposed to be banned from running in the first place. You were discriminated up. The law was unfair, which was applied on you. So you have that right to go to court and seek that particular protection that you need. And once the court declares as much, which might, as he has said, as he has correctly put it, that it's not an open and shut case. You have to make your case. Once you make your case, then IBC has also to make its case. This is the position we are in. If you tell us to go and start printing, maybe we have already done that bit. It means there is also monetary implication. We have to go back to Parliament to give us more budget. to again redo these papers. You see, this is a kind of confusion, which Parliament is not sitting.
Yes.
It's not sitting. So we're going to be now in a fix. And of course, courts, that's where the courts will now sit down and say, okay, well, you already discriminated upon. That has already been realized. But we're in this situation. Kindly let this be implemented progressively. The Constitution does speak about a lot of things. There's the 2/3 gender rule. That has always been a constitutional provision that we need to have the 2/3 gender rule implemented. But up to now, that has not happened because it's a hot cake. There's a reality fix on it. So we need to always fix ourselves with the reality because law does not come in to bring, does not act in a vacuum. It acts in a reality situation whereby if this is impossible, you also need to have a right to show up in court like IBC has and say, my lord, we appreciate what you have said. You have kicked out some of our rules and regulations, which is well within the rights of the court and sits well with the Constitution. But then, this is the situation. We have a budget which is limited. We've already given an order on a contract for this to be printed. Then what happens now? Help us. Then the court will be like, now, guys, as long as you've put in this application, we have made a determination according to the law. But there's this reality. Let's give them reprieve to do this next time.
And now, okay, it's a good thing that you've brought about the cardinal rule is that I'm not supposed to be discriminated against. Yes. Now, the other presidential candidates, there's Jimmy Wanjigi, there are a number that were disqualified because of unceremoniously. And is there a way that they can find themselves on the ballot, in August?
There is or there isn't. That is now subject to deliberations. Subject to deliberation, I can't say that there is. What has been established by the court is that they were not supposed to be barred in the first place. Because the yardstick which was used on them was not meant to be used on them. They used a higher stakeholder, a higher yardstick than what was expected of the IBC to do. But IBC was also acting within its right. IBC didn't make this law. Yes. So they were implementing a law which they're supposed to follow, which was passed by the cabinet. The regulations were passed by the cabinet because or the minister involved. Yes, they were prepared by IBC, but there was stakeholder participation. At that time when they were being passed, everybody didn't see any problem. So you can't start judging them. As far as they are concerned, they were following the law. They were implementing the law. So it has been found by the court that actually, and then you remember we are talking about 2012 regulations.
Yes.
The data protection aspect which Murima based is a judgment on is it 2019 or 2020? It's either 2019 or 2020 act actually. And it has been implemented, it has started being implemented around this time. Now, you can't blame them for a law which passed later, which was not part of the 2012 regulations. So the court simply said, kindly, we are not sure you're going to conform to this. So this, as it stands now, this is illegal. So you got to have to come up with another new aspect to look into the data project, because data is a big thing now.
And Wambui, now, are we running into perhaps one day or even now a constitutional interpretation crisis? Because Kriegler himself did say that when it comes to matters polls, we should have everything ready and set a year
in advance. Yes.
At least a year. But now we are looking at only 33 days. And some logistics have already started, the machines have already started moving.
Yes, we are 33 days to the poll, and I am wishing actually all the contestants, including my friend Moses Kamaleki in Ongatarongai ward, all the best. But I think just perhaps even before I respond comprehensively to your concern, let me just add also something that my good friend and senior has spoken about. On, I mean, will we see an inclusion? You see, the lawyers will tell you, and even people who are well learned or schooled with the law, will tell you that what is before us is attention of the application of principles. Remember, the law enjoys some presumption of constitutionality. So that any law that has not been challenged before a court of law, we assume it is legal, we assume it is constitutional. The only person who has the authority in law to make a presumption of the unconstitutionality of the law is the courts. So up until the time the court speaks, we must assume that everything that you are doing is legal. That is the legal position. So even as my senior is saying, it's the correct position. At the time the IBC was saying, no, get out of here. You do not have copies of the signatures or the copies of the IDs of people who have signed in support of your candidature. So that was the legal position. And you see, it is also a question of, there is a principle called judicial deference. That the judicial deference, legislative deference, and there is the executive deference. So that you need to defer, you need to avoid a space that is not by law your space. The space of legislating is the space that has been reserved for the legislature. Our women representative in parliament, our members of the National Assembly, and our senators at the Senate, it is their work to legislate. It is not the work of the court to legislate. So at the time these legislations were being passed, that was the legal position. The IBC is a creature created by law. It is supposed to implement what the law says so that it ensures that people participate meaningfully, at least in the elections. And that is what they did. So once they have done that, now the court has again declared some of these sections that gave them power to decline some of these nominations. Now they have declared that provision as unconstitutional. And of course the court is exercising its power under Article 65 of the Constitution. So this is a tension that we need to balance. So that, and I return back to what the Supreme Court said in the Joho's decision, that you see, the retrospectivity of whether this decision will apply retrospectively, that principle is now to be on a case-by-case basis. So that what you're saying and what my senior is saying should be put in the balance. The ballot papers have been printed.
Yes.
The gun already left. The bullet already left the gun. The horse has just bolted from the stable. So what are we going to do? Are we going to create another crisis? And now this takes me to what you had asked about Kriegler. Of course, Kriegler was just but making recommendations. But you see, the law, there are different schools of thoughts when it comes to the implementations of the law. There are judges who believe that they will make decisions even if the heavens will fall.
Even if it's one day to the election.
Yes, it does not matter, really, because they are living to their oath of office. Remember, they swore to uphold, duty. Yes, it's their duty. Yes. They swore to uphold the Constitution. So that if what is before me is unconstitutional, I will just declare that. But I believe, as constitutional scholars, people who want to ventilate on some of these constitutional issues and legal issues, what is important is for us also to ask ourselves. Because in the previous past, we have seen the Supreme Court uphold what is called, the application of what is called structural interdicts in the delivery of judgments. So that they give judgments. A judgment has been given, but there is some timeline for some people to implement that position that the court has taken, and a report to be filed to court, so that the court can understand whether there is obedience of its court orders. So I think over and above, in as much as my Lord did what is right, there is need for the courts also to take cognizance of some of these realities. 33 days to the election.
It's a good thing you're saying.
Quite a lot of confusion.
It's a good thing that Wakili is talking about, because he's saying that because they're officers of the law, he could have made this pronouncement or judgment a day to the general polls. All right, away from that. Now, we have Reuben Kigame, we have the Mwangi area, we have the Safina Party, Wanjigi. Could they also move to court? Because IBC, remember, when we were talking about the degrees, that MPs, senators are supposed to be having degrees, that was shelved to be used in the 2017, then they say, no, 2017, let's go to 2022. Now they've pushed it again. IEBC has an opportunity to say, yes, indeed, the court has pronounced itself, and we understand and we totally obey. But unfortunately, as Wakilia said, the train has already left the station. What is the reprieve that the Wanjigis, the Kigames can have, bearing in mind we have 33 days to the general polls?
the reprieve, if they so approach court, will be, as Shadrak has said, will be the best case scenario for them, not for ABC or their supporters, will be them to be included, if there is space for them to be included. That is IBC to tell us the position they are in. We're not advocates of IBC. But if they go to court and the court says, yes, you guys need to be in the ballot, and IBC does not have a good explanation as to why they cannot include them, they will be included. That is the best reprieve for them. For IBC, the best reprieve will be if they have financial constraints, if the ballot is this thing to be implemented in future. There is something else which we need to also focus as, which I need to preempt in what my colleague has said. When an application is brought before court, for example, if the Wanjigis and the others show up in court, they will be representing their personal ambitions, projections. Yes. At the end of the day, then now, once they get their reprieve, then we look at how does that reprieve apply as against the interest, public interest. IBC is a public interest thing. They have a right against the IBC, but IBC has got to act in the best interest. That means IBC needs to be funded. If they say they do not have the money, and they need it from Parliament, of course, that now, of course, it's a deadlock. The court will now say, of course, now we have heard from IBC, we rule as much. This decision, as much as this ruling was given to the effect that they need to be in the ballot, let it be applied in future. Let it be applied in future to avoid a catastrophe. We are only 33 days. By then, if they go to court, maybe it will be a week, or maybe the ruling will be in 10 or 20 days. So there will be even 20 days remaining. So maybe the reality of the practicability of them being in the ballot will be impossible. They will be said, you have done yourself a favor. You have participated in progress, or in progressing the law.
So they are not out of the
but then, thank you so much. Kindly, the public interest must be able to supersede your personal interest.
Thanks for coming, right?
Thanks for coming, and thank you for helping us. But we'll do this next time. Next time, if you're in the ballot, be sure you will be. You will not be discriminated upon.
Gentlemen, I'm seeing this scenario replicate, or it's more or less the same as what happened. EACC flagged around 240 candidates.
Yes.
And of course, I'm quite sure a lot of Kenyans were waiting to see some of the names being struck out by IEBC, including the degree saga, of which it has refused to go away. Now, they said that IEBC talked about unless the court pronounces itself and say Wambui Shadrak is so corrupt, he will not be at the ballot. The same in the case, the Sakaja's case. They said if IEBC said if the court says that no, we are not going to recognize this, then that's the only time that Sakaja can be struck out. In the same way, the corruption list and everything. So what now happens? EACC, they have been doing their research, they have been doing their investigations, and they have come up with a list that they say these people should not be at the ballot. And now the IEBC is throwing the ball squarely to the courts and saying, okay, fine, we have the list, but unless the courts pronounces itself on these names, these guys, they're going to be at the ballot.
You know,
the courts are being overworked.
No, really. It's a question of respecting the goodies that come with democracy. You know, democracy is not the best form of leadership, but it is the only one that has so far worked well. The others, like anarchy, do not work. So really, we have decided as a democratic country to bestow the power to tell us what is good and what is bad to the courts. We have said that we have a hierarchy of courts. If there is a complaint at the magistrate, there is a process of verifying whether there is wisdom in the decision made by a magistrate up until the Supreme Court. And there are so many channels. You know, these channels are meant to ensure that you get what is called fairness in the process. Now, we are also having our clients. The incoming Kilifi Governor, Honorable Aisha Jumwa, is one person who has been accused on so many things. And this is largely due to political reasons. and I'm involved deeply in these cases. I'm not going to discuss, of course, the merits, but at least from what I know, and I can confidently tell the viewers, as a practitioner of law, as an advocate who has been representing Aisha Jumwa, the incoming governor of Kilifi County, I can tell you for a fact that this law is proper. It is not sufficient that because you've been accused of corruption, that you should be ostracized from the electoral process. No. Some of these things are just meant to distract members of the public. They are meant to hoodwink them so that the members of the public are blackmailed not to voting a person who has their interest at heart, and voting a person who is probably having some, there is some liking he has towards certain quarters. You see, so you paint, when you decide to paint a donkey, you paint it, black and white colors. It does not become a zebra. And that is what has been. That is what we've been seeing. We've been branding people as corrupt. We've been branding people as murderers. We've been branding people as thieves. And yet the courts have not spoken conclusively on that issue. And this is where I return and say that I think, this is my considered view, that the safeguards that are there in law, remember, these safeguards are there so that even you, even you in the future, you will be sitting in the same position that Honorable Aisha Jumwa is sitting. And you will find yourself now, I mean, you have everything going on well for you. The people have decided it is Njue, it is Njue, it is Njue, Ben Njue. Yeah. So, and some people have now crafted, they have concocted and come up with, some scheme to deny you that favor that God has bestowed on you. So it is good and it is proper that we respect the position of courts in our democracy.
Yeah, and still on the same, gentleman, because looking at, you've said it's a good thing that you've brought about the Aisha Jumwa case, because it's not the only one that is pending in court. Yes. And the court, we always say innocent until proven guilty. Yes. But looking at some cases in the courts, because I've been at the courts for a while now, I think Sospito Jamong was charged in 2018. Yes. Eleanor Kulal, I think it was in 2020 or 2019. 2020. Governors like Gori governor, we have the Dharakanidi governor as well. But these cases, you very well know that they haven't moved an inch. Some have not even fully gone into trial. And the years keep going. 2018, 2022, you see the same names. We had a conviction of, is this Risia MP, John Waluke? Yes. And but he appealed, and he is at the ballot. He spent some days, some weeks in prison, but he is at the ballot again. Yes. So perhaps could be the judiciary be the weak link when it comes to electoral processes. Not at all, Ben. These people, I mean, EACC is just talking, we are waiting for 240 people not to be at the ballot, but at the end of the day, we see them at the ballot.
To start with, EACC is doing its duty of reporting, because that's what they meant to. If they don't, then we are going to blame them. But their work stops at investigation and reporting and bringing these people to court. But then the courts have got to make a decision. But how do the courts make a decision? If I say Ben is guilty of 1, 2, 3, as the state, I'm supposed to prosecute you. At the event that I just present you to court and run, or don't move the court. The court has got to be moved to the finality, to the end of the time where the judgment is given, like in Waluke case, which was a very successful trial. He was found guilty. But then the court will also say, if you feel aggrieved of the judgment, if you feel that maybe some things were not properly decided in your favor, or some things were overlooked, you still have an opportunity, another layer of opportunity to come up and tell us, look here guys, I'm not satisfied with this, I feel I was victimized, or the court never looked at some critical things which could have found me not to be found guilty. So you are given an opportunity of appealing. That is what Waluke has done. Yes, he served the time, but that was pending his appeal. When his appeal was approved, he was released. So he has still a duty. He is still not guilty, because a superior court is going to make a decision on whether he's guilty or not guilty. So he has to be given that much time, because he's still in the process of vindicating himself, or otherwise. So until that is done, then we can be able to. And then this aspect of blaming the courts every now and then as being the weak link, the courts do not move themselves. They are moved by either the states, especially in the criminal cases, which are most of these people are being accused of. Let the state move stiltly to the end and prosecute these cases to the end. Let them demand. The problem which we find in court, and Wakili can attest, the state comes up with the charges which are more or less trumped up, or even fair charges, but then slackens in prosecuting these cases. Once it slackens, you know, the duty for the public, they have seen somebody in court, they have been told this guy has stolen this money or he has killed somebody. But then the court do not take that public opinion and prosecute somebody and then find him guilty and convict him. It is the state to come, and this person will be given an opportunity to explain his story. The state explains his story. At the end of the day, judgment is given either in favor of the state or in favor of this person.
Indeed.
So that is how the courts work. Let's not have it twisted and start blaming the courts. It's a fair opinion which comes from the court after looking at both sides.
So if we are going to prosecution issues,
yes, it's actually mostly
you want to add something cases. On the same,
yes,
and still on election preparedness, even the Azimio, presidential candidate Raila Odinga, I think it's the day before yesterday, through his lawyer Paul, he talked about Pomwangi. He talked about that we have raised some pertinent issues, but IEBC seems to be quite sluggish in giving us a clear picture of what we want. And each and every time when you mention IEBC and somebody is aggrieved, the first thing, or even not even agreed, is to file a petition at the court.
Yes.
And say, this is, I want A, B, C, D, but IEBC is not doing that. And then we wait. At least now we are seeing cases being expedited, and the commission actually, I believe, is having an easier time because these things seem to be expedited. We've seen the cases of Sakaja and all the presidential candidates were quite expedited. Wakili, your comments on that?
Now, Njue, perhaps before I respond directly to that question, it is important that I also participate in the discussion that you have had just with my senior. On the question of the courts being the weak link. Or on my own personal accord, I have had the privilege and honor of representing the Kenya Magistrate and Judges Association alongside my senior, Mr. Danstan Omari. And one thing is for sure, is that we tend to make logic from illogical reasoning. Is that we tend to place a blame on the judiciary, while in reality, the blame should be lying elsewhere. And this is largely due to the misinformation or miscommunication of information to the members of the public. So that if you are to keenly look at probably the nomination disputes that we've been having, I have litigated one from the Political Parties Dispute Tribunal all the way to the Court of Appeal. And you see, when it comes to the elections matters, especially these nomination issues, and in view of the amendments that were done on the Political Parties Act in the year 2022, the Supreme Court, when it comes to hearing and determining matters of nomination dispute, is actually the Court of Appeal. So the Court of Appeal is the final court when determining these issues. And that is the seriousness in which you should look at disputes that have found themselves at the Court of Appeal. So in a dispute we participated, there is a member of County Assembly in Ongatarongai, Jemnyango Moses Kamalik, who had been denied his ticket. And we went all through. Within 3 months, the dispute had been heard by the ODM Dispute Tribunal, the Political Parties Dispute Tribunal. It had been heard by the High Court, and it had been heard by the Court of Appeal. In 3 months? Within 3 months.
That was quite fast.
Record time.
On Kenyan standards.
Yes, and that should tell you about the zeal and the determination that we had as councils, and of course supporting the court, so that the court would only but reflect our zeal. The court became zealous because the advocates representing the matter were zealous. So that a determination that was entered by the High Court in Kajiado on the 6th day of June, there was an appeal on the 7th day of June. Quite very fast.
Just a day.
Yes, and by the time when we were getting to the 20th day of June, The Court of Appeal, my Lord, the presiding judge and the president of the Court of Appeal, Justice Musinga, Fatuma Sichale, her leadership, and my Lord Sankale, had decided unanimously that Moses Kamalik Jemnyango was the nominated member of County Assembly. And this is with the record time. This will tell you that it is not true that the judiciary is the weak link when it comes to expediting matters.
Perhaps they are doing that.
In reality,
perhaps they are doing that because we are looking at 30 days to election. Maybe.
Yes. No, not really. Not really. If you're to look at, and this is why I want us to make a comparison. I have just made that indication so that you can make a comparison, and even our viewers can make the comparison from where they're sitting, the comforts of their house or their offices. We have seen in criminal cases, you have made mention of, the criminal cases lying in court. One where Obado is involved, the governor, His Excellency, is it Siaya?
Yes.
Now, go to the records and look at the number of times the charge sheet has been amended in that case. Every time people are ready to proceed with the case, the Office of the Director of Public Prosecutions comes up with an amendment issue. They have introduced additional evidence that had not been contemplated by the defense. So really, who is to blame? And this is not the only case. Even that of Ojamong, we have seen it in a number of cases in this country where the Director of Public Prosecutions, and of course this is because of the knee-jerk reactions when it comes to him exercising his power, if at all it is there, for him to charge people. So that he charges people on scanty information, on rumors, and he wants to amend the charge sheet through the proceedings.
But amending this frivolous adjustment, like Maraga said, is that they make cases drag in courts for years.
Exactly. You have lined up about 30 witnesses. You have overloaded a charge sheet. Someone is appearing like NYS case. You know, you should even be looking at the NYS case. You have people who are appearing in 13 files. In the 13 files, there are 13, someone has 12 offenses for each count. 12 offenses in this file, 12 offenses. When will you ever prosecute?
Not even legal.
Yes, and you have 30 witnesses.
Right.
They need to develop a strategy. Remember, criminal offenses do not expire. What is the need of, clogging the court, rushing the court, coming up with amendments, cases that do not end? While you can take one sample case, if you want to send a message, take one case, prosecute it, just have minimum number of witnesses. You have that power. You instead of taking 30, take 5.
Get concrete evidence.
Yes, concrete evidence. Expedite that trial. We have a judgment in a record 3 months, so that we will pave way for appeals. And when we have elections coming, like we have one that is coming on the 9th day of August, then you will not be having some of these complaints that you've been seeing and hearing of Waluke from, 2010. You've been hearing of Obado from 2017, and nothing has been done. It is largely because of a lack of well-trained and well-informed Office of the Director of Public Prosecutions. Because if you make
it's not the judiciary that is delaying all this.
Justice Anthony Mrima, how long does he take to make his determinations? You've been discussing so many cases that he makes here.
Yes.
He is a man that is always living on his books. He's always there burning the midnight oil. So the blame can never be apportioned to the judiciary.
All right, gentlemen. And of course, we have officers of the court. Now, looking at another election preparedness that kind of wasn't well received was last week. You do remember when the IEBC was meeting the 4 presidential candidates and the issue of the company that is tasked with the printing of the ballot papers. There were some issues that were raised. It's not the first time. In 2017, we had the same issue they had raised against was Al Gulal. And this seems to crop up again in this issue. The issue of procurement of ballot papers. It's always something that is coming up, and it's not the first time it has been challenged in court. Perhaps there's a remedy for that, because every time it is challenged, we end up in court, take days, valuable time and resources as well.
Of course, that was a very important meeting to schedule, and I want to congratulate the IBC for doing that. I think they have previously not done that, or if they did, it was low-key. This one was well attended, means that people are serious this time. So they have faith that this thing is going to, and they have to participate. And they didn't send agents. Some, of course, send agents, but the key principals were actually there to actually listen to the referee to tell them how he's planning his game, what he expects and what he does. And then he was able to take questions. You see, that is the benefit of the law. That is, we are trying to develop IBC to strengthen its wings for people to have faith in it. So that is the first thing. On the second bit, this aspect of printing has been always been contentious.
Yes,
has been contentious, but that's not the only thing. IBC is a public body. It does not absolve itself from the blame which goes around in terms of public procurement. It's a big thing. It's a lot. It involves a lot of machinations. It involves a lot of interests, which might be involved in politics or not. It could be financial aspects. Somebody wants to bring his person, or somebody is purely to make money. So that also plays an. So that's two angles. There is the political angle. There is also the aspect of some people will want to just to play around, bring their person who gives the best cut. We can't be ashamed to say that that could be something. That could be something involved. So at the end of the day, you find IBC unable to answer some very basic questions. Being a public body, they ought to come out clean. They ought to be as clean as his housewife. But at the point that they fail to answer such critical questions, then still they carry the blame. They carry the blame because we expect better of them, because they're using public resources. Public resources ought to be appropriated in a certain manner. I can't give you public resources and then you decide to use them the way you see fit. That fosters the aspect of people having insecurity. Are we safe with this person?
Indeed.
So the CEO and the chairman of IBC, I think, needs to stand tall and say, this time we can't have this, but already we are in it. So next time we expect better of him.
Yes, and still on the integrity questions, IEBC each election year, since the days of ECK, the days of Kivuito, always in the election year we have issues cropping up. And looking at today's newspaper, on the front page of one of the dailies, they've talked about one of the Kenya Kwanza principle. Wetangula. They said that he had sort of had more or less like an investment talk with the same guys who 9 months later were given the contract or the tender to print the ballot papers. This, of course, always raises integrity questions. Since ECK, since the days of Hassan, the Interim Independent Electoral Commission, IEBC. And now we are still playing the same card. Years after we promulgated the Constitution, we became a free nation, we became everything, you know. But in every election year, the integrity question on the printing of the ballot papers has to be not only raised, but has to be a topic of discussion in the country.
Yes. You know, Njue, we have traditionally demonstrated that we are people who do not have values as a country. And this must inform the reason why, while we were drafting the Constitution and giving it upon ourselves and the future generations to come, we decided that under Article 10 of the Constitution, that we are going to have what we call national values and principles of governance. So that when you are coming up with a policy, when you are interpreting the law or giving life to a certain law or provision, you must factor in some of these national values and principles of governance. One of them being accountability, transparency, and all those things. Now, this must tell us why we, even after coming up with those express provisions of the law, we keep on suspecting one another. That is why we cannot have those ballot papers being printed by Munga Designs, who is a printer here at River Road here. We cannot give you, because we suspect that the next time we give you, and probably you are thinking of someone else, you are having your uncle who is a candidate elsewhere. So you might decide to stuff some and for his own benefit. That is the level level of suspicion that is between and amongst ourselves as Kenyans. Now, this is why we have to incorporate or, give this assignment to someone else who is living very far away from us.
Yes.
And perhaps people who are little known to us. Now, the suspicion, I have seen it on the daily newspaper today.
Yes.
Where Wetangula is said to be having some links with these people. I think this is a red flag. And it must be investigated. We must see the level of, the engagement that they have. What stake does he have? Because remember,
and why them? Why not another company?
Exactly. You see, they have not looked for Njue and placed him on the newspaper, the front newspaper. No, this is my senior, Moses Wetangula, who is now one of the principals in the Kenya Kwanza. So what are we seeing? What will the people, like-minded and reasonable people who are affiliated to the Azimio or Agano Party or Roots Party, Tingiza Muti, how will these people view that one of the people who are participating in these elections as a principal in the Kenya Kwanza is having some bedroom talks with the people who are printing? There might be suspicion, reasonable suspicion of ballot stuffing. And this must inform the Algurai dispute, which was before Justice Odunga, Professor Joel Ngugi, and another, which saw its way up to the Court of Appeal on the question of the involvement of the public or the public participation in the procurement of this the company that printed the ballot papers. And this is largely the suspicion, because we are not clear on who really should be getting this tender. And I'm hoping that because we are still at the election preparedness level, we are preparing for the elections, which are 33 or thereabout days away from today, is that some of these grievances or concerns will be addressed. I am well aware of the grievances or concerns that have been raised by my senior Paul Mwangi, and these grievances must be addressed. Remember, following the nullification of the elections of President Uhuru Muigai Kenyatta, there were some recommendations as against the IEBC. Remember them being told to go and open the server, and the senior counsel Paul Mwite returns and says those people are asleep. You remember that incident? Yes. So we must not forget what transpired. We must not forget the recommendation that the Supreme Court told us. In any event, I am hoping that since the chairman of the IEBC, Mr. Chebukati, is a lawyer, is an advocate of the High Court of Kenya, must revisit the jurisprudence that has been flowing from courts, must be guided by those decisions, so that we do not have a repeat. What the Supreme Court told us in 2017 on the first day of September is that we have the capacity of declaring everything that you do as inconsequential, nullity, illegal and invalid. So we must be very careful as we approach these elections. The IBC must open its eyes. It must approach everything with great circumspection. We must be careful. That is the point I want to rest at.
Gentlemen, and because of the interest of time, you are advocates of the High Court.
Yes.
Ruth's candidate is also a lawyer and a distinguished one, a distinguished professor for that matter. Let's look at some of the things he has talked about in his manifesto. And in this light, on the legal side, he's talked about legalization of something that is illegal in the country, that is marijuana. And he's talked about the hyenas. Okay, I will not go to the finer details of how they're supposed to be done, but these things, even the animal crusaders, clergy, they are talking about, this guy is talking about something that contravenes the Constitution, and yet he's just let to campaign in manifesto. He goes to the finer details of those things, but nothing is being done. Why is he being allowed to promote things that will be challenged the first day? And another thing, a very dangerous one, is that he's talking about suspension of the Constitution, the apex law of the land. Your comments on that as we wind up, as we think it's something.
Then I'm laughing, eh?
Yeah.
Wajako is my friend.
It should be. You guys have been in court with him several times.
We've come a long way, and I think there are things which, of course, he says which shock people, but then again, not entirely, not all the things he says really shock me. The aspect of marijuana, I think even you had some party Njue was saying, that I think that what he's saying has been proven somewhere. I think we'll consider doing that. So,
but the good thing is that they're saying that it's something that should be up for discussion. But he's talking about legalizing.
We need
and the suspension of the Constitution.
The part of suspension of the Constitution is what I don't understand what it means, because that is now a red flag, which we shouldn't be able to allow. But then I understand what he was trying to maybe put across is the aspect of the fact that now we have this we have been talking of the corrupt people and how they have become a problem. I think he's thinking, I'm not so sure, he needs to explain himself. It was that, you know, we can't, with this constitution, we can't deal with these people. It has become a problem. What he was trying to aspire or to raise is the aspect that, you know, we need to maybe set the constitution aside, deal with these fellas once and for all, and then come back, which is, of course, practicality of that is what I don't understand. But that will need to take the Kenyan people to accept, because we have given you power, you can't start using it anyhow. We'll need to give you the power to implement whatever it is you are saying. If we say no, we say no.
All right. Council, as we wind up, of course, he has endeared with a lot of youth, and some people can identify with that, and especially those who have terminal illnesses and stuff, and relook at perhaps the medical aspect of marijuana. But from there, he went all the way to talking about suspension of the Constitution. How would even the situation be? Bearing in mind, if he is voted in as president, he'll be voted in using the same Constitution that he intends to suspend after taking office. A dangerous precedent, don't you think?
Yes, you know, Ben, I begin by saying that some of the, you know, issues that he raises or proposals that he raises in his manifesto may not necessarily be wished away with a wave of hand. It is important that we reflect on the merits or otherwise of what he's saying. Remember, the way I want to look at the proposals that have been made by Wajakoya, Professor Wajakoya, is that he's just you know, provoking us to wake up from our slumber, where we had you know, a certain set formula of succeeding in life, of addressing our economic challenges. It is just a reignition of our mind to find out some creative ways that we have that probably we can use to ameliorate and make life our lives even better. So that is on the aspect of you know, marijuana, and I have been participating in some of this clamor when of course in my assignments as the council representing the Rastafari Society of Kenya, where we have sought the decriminalization of marijuana, because even the World Health Organization has even declassified marijuana as one of these hard drugs alongside those of heroin and the rest. So that is speaking specifically on the aspect of marijuana and those you know, the hyena things. Remember, it's a creative way. The reason why Africans have been dying of starvation is largely because we just eat what has traditionally been eaten or been eaten by our grandfathers and forefathers. We have never ventured into the eating of grass. We have never discovered whether by eating grass you will die. No, we just think that is just a reserve of the goats, which we ultimately slaughter and eat. So if it does not kill the goats, why can't we eat? Now this is the suspension of the Constitution. Yes. Now remember, even the 2010 Constitution that we have right now is just but a clamor of some of the you know, the agitations and aspirations of people pre-2010 Constitution. So it is a rebirth of the law. So the law in itself, if you read also specifically, and this was discussed largely in the BBI decision by the Supreme Court, if you are to read Article 255, 256 and 257, the Constitution also provides for ways of its amendment, so that we just need to discuss and understand as a people what are these amendments that are there that are going to lead to probably the remaking of another constitution. We just need to understand, because until you understand, it will be difficult for you to wish away. And lastly, on this same issue, of course, the Constitution specifically says when we can have states of emergency and all those things. So even while Wajakoya might be very, you know, and sounding very good and exciting, yes, exciting ideology. Yes, yes. We need to balance. Everything that he says needs to be guided by the constitutional dispensation that we have. But there is nothing totally wrong with suggesting amendments to the constitution, hanging of corrupt individuals. That is a sentence. We are hanging murderers. We are hanging people who rob with violence. There are people who are robbing with violence, but not violently. They're just using their pens. They're just sitting in offices. We have employed them in public and state offices, but they are stealing from us.
Yes.
Because so it was problems.
Exactly. And if indeed the corruption is the menace, it is the lion that has always been in our room, or the elephant that has always been in our room. If we must deal with it conclusively by meting a death sentence to the people who are found guilty, so be it.
All right.
In China, they are short.
Yeah, actually in China they are short.
Yes.
Now, there's somebody, John Te, saying Miritini, Kizurini, Sharifa Chokocho tuned in from Kolomani, Kakamega County, KBC is lit. The kind of preparedness, this is Masekuti, saying the kind of preparedness we have in Kenya is that we only have the voters. How IBC are just competing with the court. Gentlemen, we can keep this discussion quite lengthy, but unfortunately we are out of time. Thank you so much for your valued insight, some very positive comments coming in. Thank you, Sana Wambui Shadrak. I'll always see you in court, and also Gibson, Gisore. Yes. Thank you so much, gentlemen, for your insight and for your time.
Thank you so much.
I've been speaking to two advocates of the High Court, and they are also leadership governance experts, as you have heard their insight on the political landscape and more specifically on the election preparedness. We just hear some petitions in court, some petitions at the tribunal, but they have set the record straight. So let's see how it goes.